Hear ye, hear ye, hear ye. The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. And good morning to everyone. We will begin with introductions from the court. I'm Mike Havokin, the Chief Justice, and now, by order of seniority as to service on the court, the other members of the court will introduce themselves.
Good morning. I'm Lindsay Miller-Lerman.
William Castle, good morning.
Stephanie Stacy, good morning.
Good morning, I am Jeff Funk.
Jonathan Papick, good morning.
John Freidenberg, good morning.
Thank you, members of the court. The first case for today is State versus Miranda. Counsel, you may take your places at counsel table. And is it Mr. Malia?
Yes, Your Honor.
Good morning to you. You may approach and you may proceed, and it's my understanding, before you get started, it's my understanding that both sides have up to 20 minutes to argue if you care to. Do either counsel have any questions?
No, Your Honor.
With that, Mr. Malia, you may proceed.
Thank you. May it please the court, counsel, my name is Kyle Malia, and I represent the appellant, Mr. Marlon Miranda. In this case, he was sentenced or convicted of murder in the first degree and use of a firearm to commit that felony. He was sentenced in the lower court to life imprisonment on count 1 and 45 to 50 years consecutive on count 2. Based on the arguments in my brief and the arguments today, I'm arguing that this court should overturn the verdict of the lower court and remand this back for a new trial. And unless there are questions, I plan to focus majority on my argument today on trial counsel's performance, specifically during voir dire, and how he was deficient and prejudiced the defendant there. At trial, Mr. Miranda was denied effective representation during the trial, specifically beginning in voir dire and jury selection. The purpose of the voir dire in any criminal trial is to ensure that the jury and the defendant is given an opportunity to find a jury and ask them questions to maintain that they are free from bias, free from prejudice, and that he gets a fair trial. It is the opportunity for the defendant to question the jury specifically, to uncover these issues and determine if that specific jury member is fit for this jury service. Mr. Miranda was denied that opportunity. Trial counsel...
What specifically happened? What did trial counsel do? Did they ask any questions, or did he ask any questions? Excuse me.
Well, Your Honor, the voir dire started with the state, and the county attorney asked several questions, went on for a very extensive period of time. There were several, I believe it was 3 members of the jury panel that went back for a private voir dire. Trial counsel did ask questions of those members. All of the private voir dire, all of those jury members were struck for cause outside the presence of the rest of the jury. During trial counsel's very short, very limited, what I called in my brief, a pre-opening statement to the panel, he asked 3 rhetorical questions. In the Bill of Exceptions, as the court will see, there were no individualized questions. He didn't ask any questions specifically about the facts of the case, about the individual predispositions of the jurors, of the potential jurors. And what he did was give a statement where he specifically, on no less than 5 occasions, told the jury he did not want to be there. He told the jury that his main goal was to end the trial as quickly as possible and make it as easy as possible for them. And so what I'm saying is that he didn't even participate in voir dire. Trial counsel spent the majority of his time complaining about an injury that he had, complaining about why they were so close to Christmas, and that none of it was his fault. He specifically, and quoting, he told the jury, "Hell, I don't want to be here either." He told the jury, based on his injury, that he was in as bad of a position as the jury was to be in the jury pool. And that, I maintain, is he told the jury that The trial was a mere formality. That going through the process is just a process that they have to get through, and at the end of this, the jury can find him guilty, and we'll all go home before
Would
Christmas.
that have been a strategy on the part of the defense attorney?
If it is a strategy, it is an unreasonable one. I don't believe any reasonably competent attorney, any reasonably trained attorney has the ability to tell the jury, we're just going through the process. Tells the jury that they don't actually want to be there for the trial. And any strategy that this could be is patently unreasonable. The county attorney spent approximately 175 pages of the bill of exception asking questions, inquiring of the jury, finding out if they were fit for service on that particular case. Trial counsel spent 8 pages.
Counsel,
Yes, sir.
as I recall in reading your brief, particularly in the assignment of error, but even in the argument on this issue, I don't recall reading any suggestion of any question or any topic for voir dire that your brief maintained was not asked. Did I miss it?
No. Generally, this court has held that when questioning the effective assistance of counsel during voir dire, specifically what questions and what topics and which jurors by name or by number have to be asked.
Which is all to what avail? It may have been fleeting, but was it harmful?
Yes. To answer Justice Castle's question, to finish, Justice Miller-Lehrman, is here we can't say what specific questions or topics needed to be asked because all of them weren't asked. There was no questions about the pretrial publicity that happened. There was no questions about any predispositions based on him being in custody, any questions about him being of Hispanic descent. There were none of the questions that an ordinary attorney would or topics.
Would many of those have been redundant since the county attorney fairly exhaustively asked questions?
No, I don't believe so. I believe that all of us have seen a voir dire. All of us have read voir dire. Voir dires are uncomfortable positions for jurors. Most jurors, in my experience, in all of our experience, is that they don't want to open up. And while the first question might be fleeting and the second question might be fleeting, the third and fourth questions by the defense counsel, after they've warmed up, after they've spent several hours after the state, that in my experience, in most reasonable trial attorneys' experience, that is when they start to get and tell you what they truly believe. And more information for a practitioner at that point is always needed. Jury voir dire is usually never enough time to figure out everything inside of a person's head. And to answer your question, I think, Ms. Justice Miller-Lehrman, is Mr. Miranda was prejudiced here because from the word go, trial counsel did not effectively, adequately test the state's case. From the word go, he did not participate in a fundamental portion of a trial. And under the Strickland standard, the prejudice prong can be met by either showing that the reasonable probability, or as this court has said, if a defendant is denied counsel during a critical stage, which it is undisputed that voir dire is a critical stage of a trial process. If they are denied attorney, this court can presume that he was prejudiced. And in this case, in this instant, when trial counsel did not ask any questions, did not inquire of the jury, and in fact went further and told them he didn't want to be there, told them that his main goal was not to test the state's case, was not to present evidence. His main goal was the comfort of the jurors.
Do you have authority, and remind me if you do, of why prejudice would be presumed in that
There is,
scenario?
I believe it is State v. Canbass. I cited it in my brief. It's that when the adversarial process is so fundamentally and functionally abandoned that we can presume the prejudice. That's what this court, I believe,
So
the Supreme Court.
the universe of presumed prejudice is pretty small in Strickland.
Yes, I would agree that it is very small. It's a very hard thing to get to. If a trial attorney just disappears for 3 days as a trial, I think this court would say that would be abandoning him. And what I am arguing is that this is functionally the same thing. That when trial counsel fails in their duty, fails in their ability, fails to represent the appellant or a defendant in any case to this level, that is functionally the same thing as him not being there. And in fact, in this case, had trial counsel simply said pass for cause and not done anything else, he would have left Mr. Miranda in a better position, because he wouldn't have told him that he didn't want to be there. He wouldn't have informed the jury, and the subtext that this is just a formality and we're just going through the motions to get to the jury verdict and get to Christmas. His actions went so far beyond that, and that it is, I find it offensive that this trial counsel told the jury he didn't want to be there. I would suggest to the court that it should be.
What are we to make of the fact that trial counsel was apparently extremely experienced and had years and years and years of defense work?
And his experience and his years of defense work, sometimes that helps. Sometimes people get tired, and sometimes they stop trying. And in this case, he told the jury that he doesn't even try to figure out what's in a juror's head anymore. He doesn't even try during voir dire. He doesn't try to accomplish the mission of a jury process. He doesn't try to accomplish the mission of the voir dire to find a fair and impartial jury.
If that is prejudicial, can that be cured by cross-examination, presenting evidence, things of that nature by defense counsel? Or is it it's happened, it's done, you can't fix it?
I don't think once you get to that process after you've gone through the jury selection, I think the entire jury panel is tainted at that point. Once he's told the jury that he doesn't want to be there and that this is a formality and that we're just going through the motions, I don't think there's an instruction. I don't think that there's a question. I don't think there's anything else after that point that can cure with this jury. Once that cat is out of the bag, it's out of the bag. And I think the only remedy there is for a new trial and a new jury panel, free from all of these issues, free from all of this information, free from the error that I believe trial counsel committed here.
Counsel, in response to my earlier question, you mentioned, I think, 3 potential topics of inquiry. But I don't recall, certainly not in your assignment of error, none of those appeared in your assignment of error, and I don't remember any of those 3 appearing in the argument section of your brief. Do you agree that that is an accurate characterization?
I would agree that I did not name those 3 topics. Yes, Your Honor.
Or any other topics.
Or any other topics. What I argued in my brief is that all topics, all of the potential avenues, and that...
Why couldn't a long-experienced trial attorney who was there and sized up the jurors during the course of an extremely extensive voir dire by the state make a judgment about the character and qualifications of the jurors in front of him and make a strategic decision to just try to be friendly with them, to sympathize with them, to empathize with them, and not to ask questions that may make things worse?
Not asking questions to make things worse could be a reasonable strategic decision.
So the prejudice we can't presume, can we?
The problem here is that that's not what trial counsel did.
Well, how do we know that?
Because he told us, Your Honor, in what he told the jury is that he doesn't even try during voir dire anymore to figure out what the jury's saying. He said, I don't try to figure out what you all are thinking anymore. And by his own statements during voir dire, trial counsel has abdicated his duty to Mr. Miranda.
That's the heart of your argument.
Yes, Your Honor. That is the heart of the argument, and that is, I think, the part here. And had trial counsel stood up, given a speech and said, I pass for cause, and not told the the jury that he didn't want to be there, not told the jury that he was in pain, not told the jury not to blame him for trial next to Christmas, not told the jury that his main goal was to get the trial done before the 12-day break before Christmas. Had he not done all of the things to harm Mr. Miranda's case, harm the appellant's case, that could possibly be a strategic decision. What he did, though, is patently unreasonable, in my opinion. And that's my argument to the court, is that because of his statements, because of his actions during voir dire.
Your time is dwindling, and I don't want to take your time, but you mentioned at the outset you were going to concentrate on the assignments of ineffective assistance of trial counsel. Are you, in effect, conceding that there was sufficient evidence viewed in the light most favorable to the state to support the convictions?
No, I am not conceding that part.
And how do you suggest, I presume, I gather from your brief that you are attempting to induce us to return to at least some variety of the accused rule, or to treat circumstantial evidence as less valid than direct evidence. Am I misreading your brief?
If that was the implication that the court took, that was not my intention. I'm not asking the court to overrule its precedent. I don't believe that there's cause at this point to address any of the precedent before the court. And so with the evidence presented, I believe, based on the evidence from the state's witnesses and from Mr. Miranda testifying, that there is no direct evidence of purposeful premeditation, deliberate premeditation in this case.
Aren't you asking us to reweigh the evidence, particularly your client's testimony?
I don't believe I'm asking the court to reweigh the evidence. What I'm asking the court to do is look at the evidence, and that even in the light most favorable to the state, I believe the overwhelming contradictory evidence is that he did not act purposefully, did not act with premeditation. It was not a deliberate, intentional action at that point to commit the crime of first-degree murder.
Didn't he, after he was excluded from the bar, go back to his car, retrieve the gun, and come looking?
And I believe the evidence was that he came to speak with his ex-wife or estranged wife to discuss issues. The evidence also was that the decedent here had made threats, and there was, if I'm remembering correctly, multiple witnesses who stated that he pushed the estranged wife out of the way and took an aggressive stance with Mr. Miranda. And at that point, that is when, and I think based upon all that evidence, there is enough to say that a reasonable jury could not find him guilty of first-degree murder.
Did he shoot Mr. Miranda in the back?
And you'll have to forgive me.
Excuse me, not Mr. Miranda.
Did Mr. Miranda shoot the decedent in the back? You'll have to forgive me. I believe it was, the first shot was to the front torso, but I will defer to what's in the Bill of Exceptions. Again, I did not do this trial, and so I don't remember it firsthand. I'm remembering what I've read multiple times in the Bill of Exceptions. I believe, and if the Bill of Exceptions is different, I'll defer obviously to the facts or the words on the page. But what
You're not saying that the decedent came and sought out the defendant or the appellant did, are you?
No, that's not the evidence at all at the trial. The evidence was that Mr. Miranda did return to the scene. And
With the gun,
yes.
and it's,
Followed them up the street.
That would be, yes, that would be the evidence, yes.
pulled the gun,
So the evidence there, I believe, was that the gun was not pulled until after the confrontation with the decedent.
well, there were some indications, people yelling he has a gun. That would allude that that happened before the altercation occurred, wouldn't it?
Yes.
So then the victim moves Mr. Miranda's wife out of the way and takes a defensive stance or an aggressive stance. Does that So that would be second-degree murder, or would it be manslaughter? Are we talking about self-defense?
I mean, I believe it's probably a manslaughter in that case.
Sudden quarrel?
Yes. And that was also part of the issues that we had in this case was with the ineffective portion is that during the beginning of the case, the questions and all of the strategy from trial counsel was a self-defense. And then in the end of the case...
You took a gun to a fist fight and it's self-defense?
Well, the testimony was that the decedent did threaten Mr. Miranda's life prior to that. And that Mr. Miranda was not from Omaha, believes that Omaha is a dangerous place, believes that it was necessary for protection of himself from not just the people around the bar that he knew, but other people that he did not know.
So self-defense was a reasonable strategy?
Yes, self-defense would have been a reasonable strategy, but trial counsel switched halfway through. And so part of the trial, he spent most of it with attempting to do a self-defense, and another portion of the trial he tried to do mitigating it to manslaughter and a death happening upon a sudden quarrel. And in that situation, without discussing it, and I understand that is not in the record, discussing the strategy, that is put the jury in a position where they couldn't figure out what to believe or which way to go, and based on that, I believe the strategy there was also deficient. That is all of my time. Thank you. I would ask the court to overturn these arguments based upon the argument and the brief today. Thank you.
Thank you very much. Ms. Tangeman, good morning to you.
May it please the court, I'm Erin Tangeman, Assistant Attorney General representing the state of Nebraska. I will begin where my opposing counsel left off with sufficiency of the evidence. The state submits that the evidence overwhelmingly established that Miranda committed first-degree murder and use of a deadly weapon. The only evidence of threats from the victim or that the victim squared toward the defendant and pushed Sharon out of the way come from Miranda. That is not what the state's evidence was at trial, and the state presented numerous witness testimony from unrelated witnesses who had no connection to the defendant, the victim, the defendant's wife. The evidence showed that the victim was gunned down by Miranda in front of numerous eyewitnesses, and those witnesses testified that Miranda quickly approached Sharon and Jose. He pulled out a gun, he reached around Sharon and shot Jose. Jose fell to the ground. Miranda then pushed Sharon out of the way, pushed her to the ground, stood over Jose, and fired more shots into his body. Jose was shot 6 times, once in the hand, once in the neck, and 4 times in the torso. After shooting Jose, Miranda then drug Sharon down the sidewalk and began slamming her against a brick wall while he was still holding his gun. After Miranda was apprehended by police, he was heard saying something to the effect of, "The guy got too close to my wife, so he got shot." This was a premeditated murder, and the evidence deduced at trial established that.
Let me see if I can't clarify something we were asking
Yes.
with opposing counsel. So to the extent what happened in the bar may have been a quarrel, legally speaking, right? It's over.
Agreed. I think the state's position is that it would maybe not legally be speaking a quarrel because the evidence presented was that the victim was just sitting there. Miranda came up and punched him, took him to the ground. The victim did not fight back. The victim was calm after, kind of shocked by the whole thing. This was all provoked by Miranda. Miranda was the instigator in the fight. The victim did not fight back at that time.
So the state's argument is the subsequent episode is premeditated, however brief.
However brief.
Thank you.
Yes.
The jury in this case was instructed on lesser included offenses
Yes.
and rejected those.
Yes. Sudden quarrel, manslaughter was given as an instruction as well as self-defense. So they had both of those, and defense counsel did argue both of them to the jury in closing.
Thank you.
And there are no assignments of error regarding instructions.
Correct.
How's the defense counsel's efforts in voir dire?
Yes. So I do agree, as we argued in our brief, as Justice Castle has pointed out, that Miranda failed to specifically detail his allegation of deficient performance. There's no specificity in the assignment of error itself, and in the argument portion, he doesn't identify what questions should have been asked by counsel, what information counsel should have presented to the jury. I do think if this court finds that the deficient performance allegation has been specifically raised to this court, I do think there's an argument this was a reasonable strategic decision by counsel. Opposing counsel spent a lot of time talking about the statement that defense counsel made that he didn't want to be there, but that statement has to be taken into context. He was talking at that time about everyone having a right to a trial, right to a jury trial, and told the jury that he appreciates that they were there today. And for those of them who did not want to be there today, he didn't want to be there either, but we're here, we have this constitutional right. So he was trying to build rapport with the jury. He was trying to reach some common ground with the jury right before he started his presentation, questions to the jury. We had numerous juries inform the court of, I've got plans, I'm going on vacation, I can't leave my job. As he mentioned to the jury itself, I don't have, I've been sitting here and I think everyone is fair and impartial, and the most problems I see with this jury is time commitments, other commitments, things like that. So I think what he was trying to do is, hey, don't hold this against us. I know we're getting close to Christmas. I know this is going to take over a week, but I don't want to be here either. I think that's a strategic decision, and I do not think that's ineffective assistance of counsel. Regarding his comments of his leg pain and things of that nature, he was just explaining to the jury that he was in physical pain, and if they saw him grimacing, that's why he didn't want them to take that in a negative way to what they were doing, anything in that process. So I did not see any issues there. So that is the state's position, that voir dire by trial counsel was not ineffective, and I think if you find the assignment of error has been properly alleged, that you can reject the claim on the merits.
Does the state think that any of the ineffective assistance of counsel assignments of error are adequately assigned?
Well, I will say, so I came into this case a little late simply because someone left our office. And I do agree with the majority of the positions taken in her brief, but I do think there are some arguments, especially assignment of error 6. I do not think that that was sufficiently alleged. We just have a conclusion of zealous advocacy in the assignment of error. I do not think that was proper. As for assignment of error 5, the reviewing of discovery and failing to file pretrial motions, we argued in brief, and I would agree that the pretrial motions has not been adequately stated to this court. We don't know what type of motions. His argument just says motion to suppress, but he doesn't give any grounds. Regarding the failure to review discovery, this court has found, at least a couple of times I found in my research, that that claim is not appropriate for review on direct appeal and should be found to be record insufficient, is what I'm trying to say. I do think in this case, though, given the overwhelming facts of the case, the state would also pitch that he can't show prejudice because of the overwhelming evidence of guilt. There's nothing that reviewing the discovery would have done, especially since Miranda himself testified at trial. And then the only claim that I'm not certain on is assignment of error 3. We took the position that the record is not sufficient to address the plea negotiations. I do think, there's nothing in the record regarding plea negotiations, so we obviously have nothing on that, but I do agree that the claim is pretty vague. It doesn't say if he asked his counsel to conduct plea negotiations. It doesn't say if the state would have been willing to conduct plea negotiations. So
in the bigger picture of things, if our case law takes the position that every time someone says, well, I wasn't informed about plea agreements, that means everybody gets some post-conviction opportunity to have a hearing of some kind. Is there something flawed with that philosophy?
Well, yeah, I think, the purpose of this is to actually talk to the defendant and figure out what went on, and so you can make actual claims that have at least some potential merit and not just throw out, well, he should have done this. When you do get to post-conviction, they are going to have to show that they would have taken a plea, things like that, so there is a little bit more. But I do agree, and I think maybe this court has even said before that there needs to be more alleged factually regarding whether or not, I guess it's more, I think there was a 1987 case that said claiming ineffective assistance of counsel because counsel failed to obtain plea negotiations, defendant must establish facts that would establish the plea negotiation was reasonably possible. And I think that was recently cited in the Court of Appeals. That's where I saw that case. So I guess it's up to this court. We took the position in our brief that the record is not sufficient to address the claim. And then the only...
I beg your pardon, on that one, on informed about a plea,
Yes.
is that a constitutional right to be informed about a plea?
Yes, and his allegations are not that he was not informed of a plea, but that my counsel should have done something to get into plea negotiations with the state.
Because it's constitutional because it's framed as ineffective counsel.
Yes, I believe there's case law out there that if the state gives a plea offer to defense
Right.
counsel, if defense counsel does not present that plea offer to the defendant,
But
then
it
yes.
is in the constitutional pigeonhole
Yes.
of ineffective counsel.
Yes.
That's how we get to the substance of a plea, communicated or not.
Yes.
Thank you.
Yes. The only one other thing I would like to point out is on assignment of error 5, his assignment of error did address two parts, the reviewing of discovery and the pretrial motions, but his argument contained numerous more claims about failure to take certain depositions, continuances, trial strategy, and I would just note that none of those were asserted in the assignment of error.
And on the plea negotiations, the specific assignment of error was never seeking out plea negotiations with the state. There was no assignment that there had been some plea offer communicated to the defense counsel that was not communicated to the defendant.
Correct. And his argument was similar to that as well.
Thank you.
Unless this court has any further questions, we would ask that you affirm the judgment of the district court.
Thank you very much. Do we have any time for rebuttal?
No, Your Honor.
There is no time for rebuttal. Counsel, thank you very much. That concludes arguments in State versus Miranda, and you are excused, counsel. And the next case of the day then is State versus Sullivan. Mr. Ryman, good morning to you, and Ms. Klein, good morning to you. Do either counsel have any questions before we begin?
No, Your Honor.
With that, then, Mr. Ryman, you may proceed.
Thank you, Judge. I am Corey Raymond, Seward County Public Defender. This case essentially involves, all that we're asking is that the prosecutor, State of Nebraska, be held to the same standard that this court has asked defendants and defense counsel to be, you hold them to that standard of when you
So
want to...
is there a difference between the state and or a defendant? Is there some difference in statute or some basis to treat them differently?
There is no statutory basis to treat them differently. What we have here is this gentleman is charged with a host of sexual assault charges. They end up through the discovery process, depositions, the state offers him a child abuse charge, felony child abuse charge. And there's nothing in the charge that alleges any type of sexual offense. So he pleads to that. And
Is there anything in the factual basis?
There was in the factual basis very heavily about him sexually molesting the children. So yes, there was in the factual basis.
Any objection to the factual basis, or does that matter?
He pled no contest, as I recall. And I hate it when attorneys get up here and say I wasn't the counsel, but it was the commission back then. But the plea colloquy is in the bill of exceptions. But I don't think they took issue with that.
But before we move off the factual basis real quick, was there anything other than the sexual allegations that could have acted as the basis for the child abuse charge?
What I would say not in the factual basis, because defense counsel, I don't believe, commented on that. If you read at the time of the sentencing colloquy with defense counsel, there is a very long discussion about why Mr. Sullivan did not commit these crimes, why he should not be sentenced as a sex offender, and that he accepted this plea because he's a habitual offender. It was in his best interest, and also he did place those children in a bad situation that did endanger their health for other reasons, and I believe including substance abuse by both parents. So they did find, yes, that he should have done a better job, and he acknowledged that. And that's why he took that plea. And then, so you go to sentencing, and if you look in the sentencing colloquy, like I said, is in there. And the Bill of Exceptions demonstrates that Judge Stecker read all the conditions of post-release supervision and then asks the prosecutor anything else. Ms. Passold, who is a very experienced prosecutor, says no. And so he imposes the post-release supervision conditions, which is your standard conditions with 3 specific ones, the MRT, victim empathy, and other behavioral programming. The state has the opportunity to say, no, we want the sex offender specific conditions there, and they do not ask for that.
Was that part of the plea agreement, that they not ask for it?
No, there was no agreement as to sentencing. And what I would note, it was not a sex offender registry offense that he pled to either. So Mr. Sullivan, who's been in county jail this entire time, goes and does his few months at the Bureau of Prisons, gets interviewed by this navigator, and boom, comes back with the whole range of standard post-release or probation conditions you would expect somebody who's convicted of a sex offense to be: the electronic monitoring, the no contact with anyone under the age of 18, we have access to all of your phones, all the stuff you'd expect, okay? And so they file this motion, and they want to add all of these conditions because this is a sex offense. Why is it a sex offense? Because we looked at the police reports, and the police reports tell us this was originally a sex offense. They don't care about the plea or anything like that. So there's no new material change here whatsoever. And if you look at Ms. Porter, now Ms. Porter is the probation officer that came and was available to testify. So she's the one that's on the stand enduring our questions here. She didn't do the original pre-sentence report, and she didn't do the BOP with the post-release plan. She just tried to answer questions for both ends. But if you look on page 47 of the transcript, there's a question asked of, so why do you want these modifications now?
You mean of the Bill of Exceptions?
Bill of Exceptions, I'm sorry, thank you. And she says, because the navigator looked at the police reports and saw that this was originally a sex offense, so therefore we add the sex offender conditions. That's how we do it. Well, you had that chance back at the original sentencing. You have a probation officer that knows what she's doing, that has experience. You have a prosecutor who's got as much experience as I have that was able to say, no, we need to have these sex offender conditions. And you have Judge Stecker, who's been on the bench for years. And nobody did it. So now all of a sudden you want a second bite at the apple because your navigator went in there, looked at the file, and said, oh, this was originally a sex offense, so we're going to make this guy do all these conditions. Well, you could have done that at the time of the original sentencing, and nobody said anything. And so they file this motion under 2263, and so I start looking at the cases that define 2263, and it's usually a defendant asking for a modification on his probation or post-release supervision. And this court has indicated you have to have some type of material change, or at least new circumstances that would warrant that. There are no new circumstances here. Everything that they knew at the time of sentencing, and they just want a second bite at the apple to make this guy jump through these hoops at this point in time.
Nothing, go ahead, Chief.
No, go ahead.
Nothing from the time he was in prison, no treatment, no evaluations, no behavior.
Exhibit 2 is the post-release supervision plan. The only thing that, and we talked about that, there's nothing new in there. I mean, she interviewed the victims don't want him around. Okay, we knew that before. She interviewed Mr. Sullivan. Mr. Sullivan denies he did anything wrong. The only difference I saw is the Bureau of Prisons recommended that he go through the sex offender specific classes. Now,
You mean the Department of Correctional
yes, I'm
Services.
sorry.
Is that federal vernacular that you're
It is.
using?
Yes,
Okay.
it is. I'm sorry.
That's all right.
So there, when you look at Exhibit 2, there's no new facts in there. And in fact, it's verified on page 47 of the Bill of Exceptions by Ms. Porter that this was all based upon the navigator getting the file and reading the police reports and seeing, oh, this was originally a sexual assault case, so therefore we're going to make him do the sexual assault charge.
So were the changes based on a statutory opportunity or a court rule opportunity, or what was the authority that the state and or the judge used to put in the statute?
29-2263, and this court's rule, I don't know if I have it handy, 6 dash, I thought about that up.
1904.
Thank you. Yes.
So did the court or did anybody distinguish between those two, because they don't appear to be exactly the same?
The court, I believe, the county attorney and the court both cited this court's rule when you laid out how we're going to implement post-release supervision.
The heart of your argument, though, is that on the original sentencing, the defendant has an opportunity and in fact an obligation to appeal if he disagrees with the conditions that are imposed at that time.
Yes.
And you would argue that there is a similar obligation on the state under the excessively lenient statute to appeal at that time if they think conditions have been left out.
Not only to appeal, but to ask, to bring it up at that point in time. Because
To make the record and
because they had the opportunity to ask, and they didn't even ask. If I could, I'd like to reserve my last minute.
Thank you very much. Ms. Klein, good morning to you.
May it please the court, Mr. Chief Justice, I'm Kimberly Klein, Assistant Attorney General representing the state in this matter. I think what happened here is really precisely what's contemplated by this court's rule in 6-1904. They essentially have to, by statute, front load terms of post-release supervision, even though they don't really know what he's going to be doing while he's incarcerated. The reason we've got the review of the post-release supervision conditions close to the end of his incarceration is so that you can tailor them to what will be useful to him and what will most likely be calculated to reintegrate him into society.
Counsel, your opponent argues that there's nothing that occurred during that period of time between the original sentencing and while he was further evaluated by the Department of Corrections that suggested that additional conditions or terms were needed. They all related, he argues, to what was already in the record at the time of the original sentencing. Do you agree or disagree with that factual representation?
To a degree, I disagree with it, Your Honor. Part of the reason the conditions were sought to be modified is because the navigator essentially went beyond what the plea agreement was. It was felony child abuse.
All the materials relied upon by the navigator were in existence prior to the sentencing, correct?
That's my understanding, yes.
So in the sense that there's something that came out of behavior or evaluations or classes during the period of imprisonment, there's nothing in the record on that, is there?
Not to my recollection.
All right.
The navigator isn't the person who does the initial probation report. The navigator enters the picture at the time when
And does that make a difference?
I think it does. I think it does, because the navigator has a different, essentially, function than the probation officer does. The probation officer is setting up what the sentence will be. The navigator is setting up what the terms of post-release supervision when he's actually released ought to be.
Is there some problem with a kind of double jeopardy problem here?
Oh, I wouldn't think so. He's not being punished twice. They are simply modifying terms and conditions of what his essentially probation will be once he is released from incarceration.
Can you do that? What's the authority to do that?
Well, what is it, 2263 permits it, and this court's rule, I think, of 1904 also.
So 2263 seems to talk in terms of when someone is on probation, you can modify terms. So was this individual on probation, or is this individual, if you've got a term of post-release supervision, are you on probation the entire time during your prison term and everything?
No, probation is, you have incarceration, you have probation once you are released from incarceration. It's a sentence like that is essentially a two-step process.
Could the court, did the court have authority then under 2263? Does not 2263 talk in terms of during the term of probation you can modify?
That's correct. And I think that's why mostly we rely on 1904, which is specific to post-release supervision and talks about what needs to happen 45 and 30 days prior to his release. And I
How
think
did we reconcile 1904 with 29-22-63-3? Did we sort of reconcile those in the Dill opinion?
Well, I don't know that there's that much reconciliation that needs to occur, because 2263 is once he's on probation or post-release supervision, same really, and 1904 talks about essentially what happens to put him on post-release supervision, what you can do to tailor those conditions of the order once upon his release, and then essentially after that 2263 takes over.
Is the rule entirely consistent with the statute?
I have to say I didn't necessarily see any discrepancy.
Well, I think we said in Dill to some extent they're addressing the variations in the course of release.
Yes, like you said, if the court modifies the post-release order, it has to do so prior to his anticipated date of release. And that is, I think, what 1904 is directed at. And once he is actually released, then you essentially rely on 2263.
I'm sorry, I interrupted somebody.
Can you help me? This section 6-1904, does that have an internal reference to section 29-2263?
In Part A, court shall specify on the record the conditions of post-release supervision may be modified or eliminated pursuant to 2263 sub 3. So yes, it does reference that, and to that extent they are interrelated.
And doesn't one of the statutes also require that same announcement to be given?
Yes, I'm not sure which one it is, but I do recall coming across that. And he was, in fact, told that they could be modified at any point in time.
So I'm perhaps hearing two different things, and I don't want to mischaracterize what you're telling us. But I thought I understood your argument to say this isn't really a modification, a 29-2263 sub 3 modification at all.
Yeah,
It's not
because-
modification because post-release supervision / probation hadn't started.
Correct.
It's something else.
Right.
And what's the statutory authority, not our rule, but the statutory authority for modification during that period of time?
Yeah, I knew you were going to ask that. Let's see. I'm thinking it's 2262. I'd have to give it a more thorough read, but I think it relies on 2262.
Do you think there is one?
I would hope so.
If there isn't, do we perhaps have a problem?
Yeah, I think you might. I think, let's see. Okay, 2262 says when a court sentences an offender to probation, it needs to attach reasonable conditions, and it may require him to do.
Yeah, and that one's not specific to post-release supervision at all.
No, that's just probation, but if you look at the post-release supervision probation statutes, post-release supervision is a flavor of probation, so I would think that it would be encompassed within that statute as well. And so, yeah, 2262 is fairly lengthy. I think it's somewhere in 2262, I'll put it that way. But what happened here is part of the reason that this came up is because of some internal, as the probation officer testified, the navigator went in and looked at this and said, because of our internal probation office rules, he can't sign up for just the regular crime victim empathy and the, was it MRT, I think, thing, because of the factual basis of what he's got. Our internal rules require that if he's going to do these things, he has to do them in a sex offender specific status.
So,
Well, who's driving this? Excuse me.
well, it's the same question. What are these internal rules, and are they in the record?
No, they are not. We have her testimony that this is what the probation office rules and requirements are. And as to who's driving this bus, well, the statutes seem to give both the court and the defendant and the probation office all a key to the car, because any one of them can move to modify at basically any point in time. And so at this point in time, it's the probation office in the driver's seat, and that's how we got
So
to
now
where
we're
we are.
back in the modification realm?
I keep calling it a modification. It's a modification of the original. I'm not talking about a modification of probation. I'm not sure there's a better phrase for it. It's just a modification of the original PRS order, and so it's not a modification of probation itself. It's a modification of the original probation order, which they are entitled to do.
Before post-release supervision starts?
Yes. Yes, because.
I guess that takes us back to the question we were discussing earlier, but I'm not sure I ever heard the answer to it. Does the statute expressly authorize the court or probation or anybody to modify terms of post-release supervision after it has been imposed and before it begins, during that window?
No, I don't. Specifically a statute that says you can do that, I don't recall that there is one. I think they were relying on this court's rule, because it lists basically that 45 days prior to his release, the court's supposed to get the order, and within 30 days of his release, they can modify the terms of the original order.
Pursuant to the court rule.
Pursuant to a court rule, yes.
Where does public safety fit into all of this? Recognizing that the probation officer will have the legal duty to supervise this person while they're on post-release supervision. Where does public safety enter into our analysis?
I think there's nothing in statutes that I recall that actually says anything about public safety. The probation officer took it into account. In her testimony, she said, a lot of times the victims are very concerned and uncomfortable with a person like not having a GPS monitor And so that's frequently one of the terms we will impose as a result for basically public safety. Statutorily, specifically, I don't think there's anything that specifically references public safety.
Referring to our case law, is post-release a part of a sentence?
Yeah, I think it is, because it's a part of a probation, and if probation is part of the sentence, so you kind of have to mush them together, but yes, I think it is.
So what's your best argument why the state should not have been required to appeal from the original sentence as excessively lenient if indeed it wanted these conditions that were subsequently imposed?
Again, it goes back to, there are multiple keys to the bus in this case. The probation office is who sought the actual modifications, not the state. And the probation office said the navigator sees that this is a sexually based offense, and based on our internal rules and regulations, this is what has to happen. And I don't know what their internal rules and regulations are. I doubt that any prosecutor in the state knows what their internal rules and regulations are. So this thing was actually being driven by the probation office, not the state. And there's no way to know what their internal rules and regulations.
So does the state have some opportunity to either dismiss what the probation office has filed? Does the probation office file something with the court? Is this how this works?
I don't know that I can answer that. I don't see that the state has any authority to.
Does your office have some authority at this stage to say, we're not going to defend this action?
I don't really think we do, Your Honor. It's the way I understand this to be written, it's that the probation office, the defendant, or the court on its own can ask to modify or seek to modify the rules and, you know, the requirements of the post-release supervision, and whoever does that basically starts the ball rolling. And I'm not sure that there's anybody, I can't stop it when somebody else has started it. That's my understanding of how this works so far. And I know I'm over my time, but I'm going to take just a moment that has nothing to do with this case and thank this court, because this is my last argument before you. After 33 and a half years, this is finally it. I appreciate your consideration and your probably indulgence sometimes with my arguments, and it's been an honor and a privilege to appear before you for all these years, and I thank you.
Thank you for your 33 and a half years.
Thank you, Your Honor.
Thank you very much.
I find it distressing when people who appear to me to be younger than I am are retired.
If we weren't in court, I'd say, bless your nearsighted little heart. Thank you, Your Honor.
Thank you very much. And do we have time for rebuttal?
Yes, Your Honor, 52 seconds.
Mr. Ryman, I want to ask you right off the bat, if indeed the state has to show some change of circumstances before the terms of supervised release could be implemented, what would the state have to show? What would the state's burden of proof be?
I believe they could do that with a thorough post-release supervision plan that demonstrated, I've met with this individual, here's the programming that he had, here's what the Department of Corrections was suggesting, and the gaps that they have.
So would the burden of proof be preponderance of the evidence or beyond a reasonable doubt? Or
as a defense attorney, I'll say clear and convincing, but I do think I will agree, it's the state's burden at that point in time to show we need to come in, and it's our burden to prove, here's why, subsequent to the original sentencing, here's why we need to change this. So I do think it is the state's burden to prove that.
We just don't know what the burden would be.
as high as just you're willing to go. But a couple things real quick. There were some questions about gaps in statutory. I would note in State versus Dill, the court did a pretty good job, a real good job of trying to lay out how this post-release supervision works. And if you look at some of those footnotes from the court about amending the supervised release subsequent to sentencing, they're going back to you're citing the court's own rule, not the statute. So I do think there's a statutory gap, and the court is attempting to fill in those holes with their rules and with their.
How does this come to be? Is it the probation, the navigator makes a recommendation to the state files the motion? Is it the navigator gives it to the judge looks at it, makes the call? How does this process work?
In this case, I can tell you the navigator filed the motion to modify with the court, and I believe that's in the record, and they cite 2263 on there. The county attorney then kicks rocks and says, gosh darn it, I have to go defend this in front of the right, and starts trying to get the probation officers to come defend what they want to change. So it was the state probation office that instigated this, and then the county attorney came in to defend it, I guess.
Your client has not in this appeal attacked the validity of the rule that this court approved, right?
I think the rule and the case law defining 2263 are, I don't think they match up very well. I think they're in conflict because 2263.
That's not the question I asked.
Okay.
The question I asked is, you haven't attacked the rule, right?
No, I have not
Okay.
specifically.
And you haven't attacked the constitutionality of any
No.
of these schemes?
No, and I think, when they drafted this post-release supervision, they attempted to basically cram in the post-release supervision into the probation statutes and say we want it monitored consistent with that. So
And the definition of post-release supervision is probation. Is that correct?
I believe that's
And a
probably,
person on post-release is considered a probationer.
I do remember that part, yes.
So it is intended to fit within probation
Yes,
by the definition set forth by the legislature.
yes. And just the last thing I wanted to say is, I asked the probation officer, you guys are aware that there's sex offender specific type of conditions you can put on this? Her response was yes. And probation chose to not recommend that at the time of sentencing. That's correct. So they knew about it, they could have done it, and they chose not to at the time of the original sentencing, and the state is just asking for a second bite at the apple.
Or the state could have asked for it even on its own.
Yes.
Or the
yes.
court could
The
have
court could have as well.
done it on its own.
Yes.
And at that point, your client would have a right to appeal based on the plea agreement, the charge actually convicted of, whatever basis.
Whether it was
he
narrowly
wished to do.
tailored type to the offense type of thing, yes.
So that's your strongest argument is there wasn't the opportunity to appeal. Well, let me back up. Those things weren't before the court, so he didn't know he should even appeal that issue.
Yes, like I said, I think your case law says a defendant has to bring that up at the initial point of sentencing, and I think that's what case law says, and I think the state should be held to the same standard.
And we've said that in Dill or Paulson or
Yes.
one of them.
Isn't this, the problem that arises here is that essentially in any criminal case, there's three entities. There's the defendant, there's the state, and then there's the court.
Yes.
And the probation is an arm of the court.
Yes.
And now the arm of the court is now coming up and making this request. Now, the state, like you said, stepped in and said, okay, I'll give you the opportunity for the probation officer, I will put him on the stand and allow the questions to be asked. But that's where a lot of this issue is arising, is that an arm of the court is acting almost as an advocate.
Yes, I would essentially agree with that, and then the state had to come in and advocate on behalf of the probation office. Thank you for your time.
Thank you very much. That concludes arguments in State versus Sullivan. Counsel, you are excused. And the court will go on to the next case of the day, which is State versus Garcia. And I should note that Justice Frydenberg is recused in this matter, and the court, Judge Arterburn from the Court of Appeals has joined the court for this argument. Counsel, good morning to you. Mr. Pickens, good morning. And Mr. Smith, good morning to you. Both sides have up to 30 minutes in this particular death penalty case argument. Do either of you have any questions before we begin? Then Mr. Pickens, you may approach and you may proceed.
My name is Jeff Pickens. I work for the Nebraska Commission on Public Advocacy. The commission represents Anthony Garcia in this automatic direct appeal. The commission was appointed to represent Mr. Garcia in March of 2017. Before then, Garcia was represented by some Chicago area lawyers who called themselves Team Mata. I just get this right out. They were a nightmare. Team Mata is a nightmare, and I think that's clear from the record. Team Mata was comprised of Robert Sr., Robert Jr., and Allison Mata. The Matas were retained by Garcia's parents and brother. They were admitted pro hac vici and were required to work with Associated Nebraska lawyers. Before trial, Allison Mata made extrajudicial statements about this case to the media in violation of the court's protective order and also in violation of the rules of professional conduct. And when she did that, all of the associated lawyers withdrew, leaving them without their pro hac vici status. They found new lawyers who were willing to sign on with them and reapplied for pro hac vici status. Robert Sr. and Robert Jr. were readmitted, but Allison was not readmitted.
And what was the reason for that?
Because of the violations. The violation of the protective order and the rules of professional conduct. What she did, they got discovery from another murder case, and there was some DNA testing in that. And I think that there was a mixture of two people, and somehow she managed to argue that it somehow cleared her client, and that she told the media that it exonerated her client and that she expected the prosecutors to call her and say they were going to dismiss the case. Well, when the judge allowed them to have the reports from the other case, I think it's Blanchard is the victim in that case. And that case might be before you now, I can't remember the defendant's name. But when the judge allowed them to have those materials, he issued a protective order and said that they couldn't do exactly what she went out and did. And of course, what she did was also a violation of the rules of professional conduct. One of the associated lawyers that that worked with them is Jeremy Jorgensen. Of course, you know about Jeremy Jorgensen. This court disbarred him in 2019. And I should say this court also disciplined Ms. Mata in January of 2018. But the loss of Allison to Team Mata was huge because from everything that we're able to get from the record, and I want to first admit that I have not read the entire record. It's a monster. It's the biggest record I've ever seen. But from what Robert Jr. Said during hearings, it appears that Allison was the only lawyer who was really prepared to take this case to trial. So when they lost her, they lost the only prepared lawyer they had. And from the mistakes that they made during the trial, it's pretty clear that at least Robert Jr. did not know what he was doing. In October of 2016, a jury found Garcia guilty of 4 counts of first-degree murder, 4 counts of using a deadly weapon, and 1 count of attempted burglary. 2 days later, the same jury found 2 aggravating circumstances that existed for 2 of the murder counts and 3 aggravating circumstances that existed for the other 2 murder counts. In March of 2017, the commission was appointed to be co-counsel with Team Mata. Not too much later, Team Mata withdrew, and we took the case over. We represented Mr. Garcia at his mitigation hearing and at the other sentencing determination proceedings before a 3-judge panel in June of 2018. We also represented him at the time of his sentencing hearing in September of 2018 when he received 4 death sentences. From the time we were appointed in March of 2017 through the sentencing hearing in September of 2018, we made many attempts to communicate with Mr. Garcia and never, ever received a response. And I think from the record, the Matas told the judge numerous times that Mr. Garcia stopped talking to them at the time that they filed an interlocutory appeal from the order denying Allison pro act vici status.
Just before you go on, a large part of the defendant's brief on appeal focuses on assignments of ineffective assistance of trial counsel. Just to be very clear about this, the commission is in the position of being partly trial counsel and partly appellate counsel, right?
Yes.
And so consequently, under our post-conviction jurisprudence, you would not have the opportunity to raise matters that occurred after your office came into this case.
That's right.
Not on direct appeal.
And that's one of the reasons why we wanted the Matas out, is so that we could raise ineffective assistance of counsel for the things that they had done, before we were appointed. We did not want to work together as a team because then we wouldn't have been able to raise those issues. So yeah, obviously we can't raise our own ineffectiveness. This appeal was initially assigned to Commission Lawyer Sarah Newell. She drafted the brief that was eventually accepted by this court in December of 2021. After Ms. Newell's employment status with the Commission changed, I reassigned the case to myself. I did not write any part of the appellate brief. As I said, the Bill of Exceptions is a monster. It's the largest Bill of Exceptions I've ever seen. Somewhere in the record, there's a photograph of the Bill of Exceptions on a cart, and physically, it's just huge. And I knew that there was no way I was going to be able to review that entire Bill of Exceptions, so I didn't even make the attempt to do it. And I am relying on Ms. Newell's brief and also Mr. Smith's brief and the issues that I intend to discuss today. The issues that I do want to discuss, though, there's the jurisdiction issue that was raised by Mr. Smith in the Appellee's brief, and then issues regarding the 1B and 1D aggravating circumstances, and then just a couple of the ineffective assistance of counsel issues. And I may fall into saying IAC, abbreviating it, and so I know you'll know what I mean when I do that. The IAC issues, though, involve Allison Mata's extrajudicial statements, and then also the allegation that she and their defense investigator tampered with a key witness, the stripper Cecilia Hoffman. There is obviously an issue regarding competency. I do not intend to raise that today because the most compelling evidence that he was not competent at the trial level is not in this record. I recently filed a motion for new trial in district court raising an issue with his competency and providing the evidence that I think is the compelling evidence that he was not competent when he was in district court. And of course, that's not in the record before you, so I'm not going to discuss that further unless, of course, you want me to. The jurisdiction question. Mr. Smith argued that the court cannot consider the counts for which Mr. Garcia did not receive a death sentence because we did not file a separate notice of appeal. 29-2525 provides, in cases when the punishment is capital, no notice of appeal shall be required. I don't know if it's necessary to look for a definition of cases. I didn't look for a definition, but obviously a criminal case would include all of the counts filed in the case.
Mr. Smith cites a case.
Rust.
Yeah, and I'll confess, I didn't look at that, but what does that tell us?
Well, what Rust says, and here's the pertinent language in Rust. Automatic, and this is a direct quote, automatic review of the death sentence has come to this court on the murder charge under the provisions of sections 29-2525 and 29-2524 RRS 1943. No appeal has been taken on the other 3 counts. The other 3 counts, he shot at some other people. I think he hit 2 of them and injured them. He shot at a 4th person and missed that person. Russ did not assign error with respect to those counts. So there was not an issue before this court about how to interpret the statute and whether a separate notice of appeal is required. To the extent that the court did hold that a separate notice of appeal is required, I think is dicta. It certainly wasn't necessary to resolve the issue. Again,
I beg your pardon, you're making a distinction between assignments of error and a notice of appeal. I hear it.
Because I think this court has done that.
So
in
with
cases.
respect to assignments of error, maybe I'm misunderstanding it. Are there assignments regarding the use and the attempted burglary?
In our case, well, there's ineffective assistance of counsel that goes
By way of ineffective counsel.
Right. Yeah, only through IAC. Yeah.
Thank you.
Anyway, as I said, I think that the language "no appeal" has been taken on the other 3 counts. That might mean there's been no assignment of error, because there hasn't been. But I don't think that is a holding. I couldn't find any other case that held that a separate notice of appeal is required. I would ask you to look at State versus Sheets, 360 Nebraska 325 from 2007. And I know you all know the Sheets case. He was convicted of murder and use of a knife to commit a felony, and he was sentenced to death. And then because of a confrontation violation, both convictions were reversed and remanded for a new trial. The case was before this court on a mandatory direct appeal. I did whatever I could through justice, through the appellate court and the trial court, and could not find any separate notice of appeal filed by Sheets.
The Sheets opinion did not talk about it.
Sheets opinion did not talk about it. That's right. It did say this is an automatic direct appeal, which this court says in every one of the death penalty cases, but it did not address whether there was a separate notice of appeal or whether there needed to be one, but it did reverse the use count. Anyway, I believe the statute is clear. There's no need to do any sort of interpretation. And when it says in death penalty cases, that includes the other cases that were filed with it and where the defendant was found guilty. I want to go to the aggravators next, 1B and 1D, and I think our argument is pretty strong here. For all 4 murders, the state alleged 1B, 1D, and 1E. B is the concealing, D is the especially heinous, atrocious, cruel, or manifest exceptional depravity, and F is the multiple murder aggravator. So in all four of the murders that they alleged those, there were obviously jury instructions on the aggravators. For the 1B, the court told the jury it did not need to be unanimous with respect to whether Garcia was concealing a crime or concealing the identity of a person who committed the crime. The jury instructions did not identify a particular crime that Garcia allegedly tried to conceal. In Sandoval and Lauder, this court said that the murder that the defendant is attempting to conceal has to be something other than the murder itself. And that language should have been in the instruction. That's plain error. It's also ineffective assistance of counsel because the team MATA did not object or propose a correct instruction. The 1D is really easy for this court to decide. The jury was instructed for the especially heinous, atrocious, and cruel prong, they can consider the victim's mental anguish. Of course, in Sandoval, which came down prior to this trial, this court said mental anguish is not a part of aggravator 1D. And then there was the Torres opinion that came down later, where Torres waived jury for aggravating circumstances, And his panel found both prongs of 1D, and the panel included the language about mental anguish. This court was able to say, okay, that prong is bad because of the mental anguish, but there's strong evidence, compelling evidence, whatever, sufficient evidence of the other prong, so the 1D can stand. But in Sandoval, this court said the 1D has to be disregarded because both prongs were alleged, and you can't tell from the jury's verdict how they decided that. So I think it's super easy with respect to this case to throw out all of the 1Ds, disregard all of the 1Ds, as was done in Sandoval. The 1B.
Is there something other than mental anguish to atrocious, the 1D prong?
Yeah, arguably, the victims died, a violent death, but
Their throat slit.
But that's common. That's common in many cases that the victim dies violently, and I think this court has addressed that. But again, the jury instruction and the jury verdict doesn't give you any insight. Both aggravators are alleged. Mental anguish is part of the definition of the especially heinous, atrocious, cruel. Sandoval says you have to disregard it, and I think this court needs to continue to follow that holding and disregard it. I know I have a heck of a lot of time. I'm usually have to stop mid-sentence and sit down. I'm ready to move on from the 1B and 1D unless there's some questions about that. I do want to talk a little bit about ineffective assistance.
Disregarded 1D, do we still have 1B and 1E in each of the?
No, we just have, I think you have to disregard 1B because in 1B, there's not a crime identified, the other crime, and it doesn't include the language this court said that should be in there in the Sandoval and Lauder case, that it has to be a crime other than the murder itself. I think that there was some language in there about the jury's left to speculate. Now, in Sandoval, it was easy. I mean, obviously, and I represented one of the defendants in the bank case, but that was easy to identify the crime. It was obviously an attempted bank robbery. But it's not so easy in this case to come up with a crime that Garcia would have been trying to conceal or to conceal the identity of the person who committed the crime. And I think you have to speculate to come up with a crime, and that's the problem. There was one other case that I wanted to discuss for that, and I don't think is discussed in Sandoval or Lauder, but it's the Myers decision, the original Malice case from back in, I think, '94. Myers was convicted of second-degree murder and use of a weapon to commit a felony. And this court reversed both convictions on the use. You reversed because there was no definition of felony. And he said, a typical juror doesn't know what a felony is, and they would be left to speculate. So you have to identify the felony. And I think that holding applies very well in this case with the 1B, that you have to identify the other crime.
Is that aspect of Myers good after this long journey on second-degree murder?
That part is still good. The malice part isn't, because Burleson overruled Myers. Right.
Okay. Thank
you. But Burleson didn't touch the use part of that.
Thank you.
What about if, for example, in each of the houses where these murders took place, 2 people were murdered? So is there some argument that at least one of the persons murdered on each of those occasions was done to make sure that the surviving individual couldn't tell anyone about the other murder?
So, for example, Shirley Sherman was killed so that she could not identify the person who killed Thomas Hunter.
Or vice versa.
Or vice versa, and the same with the Brumbacks.
Right.
Right, but we're speculating, aren't we, when we say that? And you know, the fact that that the jury didn't find the 1B on the, I don't think they found the 1B on the Shirley Sherman and Thomas Hunter. Let me go back and look at my notes here, but I don't think they found the 1B. No, they did not find the 1B on the Hunter or Sherman murders, only on the Brumbacks. So, I mean, if you wanted to speculate, I think you would speculate that Garcia killed the Brumbacks to conceal the commission of the murders of Thomas Hunter and Shirley Sherman, which were several years later. But, you know, actually, it's just the opposite. Because of the Brumback murders, the police were able to clear the Thomas Hunter and Shirley Sherman murders. They weren't making any kind of progress in that investigation until the Brumbacks were killed. And then they quickly put things together and arrested Mr. Garcia. So, you know, it's sort of the reverse of that. But again, the jury didn't find the 1B on those first two murders.
In regard to speculation, we essentially are talking about what did a collective jury do, and isn't there always some element of speculation in regard to jury decisions?
Well, there doesn't need to be. If you identify the crime that Garcia allegedly attempted to conceal, then there's no need to speculate. You tell them that. You know, when I do trials like this, I ask for that. I ask for an instruction that tells the jury what the crime is, and I always get it, you know, for what that's worth, because it makes sense, you know, for the jury to be told that.
If some jurors thought it was one crime and other jurors thought it was a different crime, would that preclude the finding of the aggravator?
If both of those crimes were identified in the instructions, and the jury was told they don't have to be unanimous on you know, on whether it was.
You just have to find one.
You just have to find one, right? They all have to find there's one. They don't have to agree on which it is. And this jury was instructed on that, but they were not instructed on what the crime was. They were instructed. Some of you can find that it was a murder to conceal the commission of a crime, and others may believe it was to conceal the identity of the person who committed the crime. But we don't know what the crime is. We don't know what the crime is with the Brumbacks.
Assume we throw in with you on this argument. What's the resolution of it?
Well, all you have then is the 1E multiple murder aggravator for all four of them. No other aggravators. And I think in the case needs to.
You're talking about, however, instructional error, aren't you? So is there a new hearing, a new trial, if you will, on the enhancement?
No, I think you would. Okay, Sandoval, you didn't need to reverse because he had three other solid aggravators. In this case, when you throw out the 1B and the 1D, all you have is 1E. And I don't think that's enough for this court to say, good enough, we can affirm the sentences. I think you need to send it back for resentencing. You know, whether you need to send it back for a new aggravation trial or you need to send it back to have a 3-judge panel do the weighing that's necessary, I'm not certain on that. You know, I suppose I would argue that you need to go back and have another aggravation trial, and the jury needs to be properly instructed. Okay, so the ineffective assistance of counsel for Allison's extrajudicial statement and her witness tampering, obviously those things are deficient performance. Nobody could argue otherwise. And Garcia was prejudiced by those. With regard to the extrajudicial statement, he was prejudiced because he lost the lawyer who was prepared to try the case. And the other members of Team Mata obviously were fairly clueless. I mean, if you look at Mata Sr.'s closing argument in the aggravation trial, where he only went for a few lines, and he told the jury, you've seen a lot of, I can't remember the exact language, you see a lot of gore on television, and then I would ask you to consider your religion. That was his closing argument for the aggravating circumstances. So Garcia was prejudiced by not having Allison there because their other lawyers didn't know what they were doing. And then for the witness tampering.
You have other examples of they didn't know what they were doing?
They're all through the ineffective assistance claims in the brief. I think the brief tells this court that after Mr. Garcia was found guilty, at least Robert Sr. and Jeremy Jorgensen went to Tom Riley, the public defender in Douglas County, and said, hey, what's this aggravation trial all about?
So is that incompetence, or is that a sign that they were trying to do a good job?
Well, you go right from the guilt-innocence trial into the aggravation trial, one right after the other with maybe a day in between, a day break in between. You have to be prepared for the aggravation part of the trial when you're doing the guilt-innocence part of the trial. And for them to not even know what an aggravation trial is about until after the guilt-innocence trial, and for them to go to Riley and say, is it because he used a gun? I mean, it shows you how clueless they are. They're going to be educated, to try to be educated, but at that point it's too late. But it shows you that clearly competent counsel doing a death penalty case would know Nebraska's aggravating circumstances. And these lawyers obviously didn't. And unfortunately, with respect to the mental anguish, it appears that Judge Randall didn't know, and he should have known. I mean, he should have read Sandoval, and he was on the Torres panel. So he should have read Torres when it came down. In fact, we filed a motion asking them to, we objected to the panel considering these aggravators, and I'm making the same arguments I'm making today. And Judge Randall distinguished Sandoval by saying, look, in Torres, the Supreme Court said you go to the other prong. If the especially heinous, atrocious, cruel prong is bad because of mental anguish, you can go to the exceptional depravity prong. But the difference is that was a 3-judge panel determination, and they made specific findings on both prongs. So you could disregard one prong and say that the other prong had been met. So the witness tampering, the thing that bothers me the most, I'll confess, I had a difficult time reading our brief. I had a difficult time understanding our brief. But it appears that there's an allegation that Allison's witness tampering is consciousness of guilt or consciousness of a weak defense that was imputed to Mr. Garcia. And I think that was argued in closing by the prosecution. I'm not sure if there was an instruction on that. But we all know about consciousness of guilt, and it's not uncommon for there to be an instruction. But that's when the defendant is tampering with the witness. When the defendant's lawyer is tampering with the witness, and that is imputed to the defendant, that seems so wrong, and clearly that's ineffective assistance of counsel, deficient performance for sure, and he would have been prejudiced by that.
How big a part was that of closing argument for the state?
I know the state argued that. I don't know the closing argument of the state as well as I ought to. I'll confess to that. I know it was argued. And I know to juries, things like that are a big deal. If a defendant tampers with a witness or tampers with evidence, you can see a guilty verdict coming down. I mean, that's just going to happen. So again, I confess that I'm not as familiar with. I'm not familiar with the record. Part of it before the hearings that we did in district court, I read.
So it seems to me that part of your brief argument was after Allison, shall we say, got into trouble and was kicked off Team Mata, then everybody who was left on the team, including local counsel, seemed to be more interested in protecting her reputation and their reputation than in being counsel for Mr. Garcia.
And the brief argues that the court should have seen a conflict of interest and should have addressed that. And the brief also argues that they should have withdrawn from the case. You know, especially after the witness tampering allegations, they should have, all of Team Mata should have dismissed.
What is your authority for that, and how would that work in real life?
Well, in real life, the lawyers would file a motion to withdraw, and I think the judge would allow them to withdraw, and then.
But the brief says that there's a duty of the court to investigate that or to question the defendant about this potential conflict of interest.
That's what the brief argues, right.
I think that's the question the chief was trying to get at.
Oh, I'm sorry.
What authority do you have for that?
If there's any authority that's in the brief, I don't know. I don't know. Well, I've used all of my time. Thank you.
Thank you very much.
Thank
Mr. Smith, good morning to you.
Good morning. May it please the court, James D. Smith, Senior Assistant Attorney General appearing for the state of Nebraska, and also referring to Mr. Pickens. I appreciate his work as always. We've worked together. Both of us have done, for example, a joint presentation to the District Judges Association on CLE for post-conviction. So we've worked together. I have great respect for him. I appreciate the difficulty he's had with this case. I did make the comment to him back in the lawyer's room that when I came here, I did a little analogy thinking I feel somewhat like the gecko in the Geico commercial where at the end he says, I don't know what we were talking about. My problem in preparing for this case was, I would say, was somewhat, I don't know what we're going to talk about today because we have a 7,500-page bill of exceptions. We have a 453-page appellant's brief, and we have 130 assignments of error. I agree with Mr. Pickens' comment that their brief is difficult to read. At times I found it almost impossible to read because it's confusing. It makes references to other parts that are incorporated by reference that couldn't figure out what they were incorporating by reference. And I do acknowledge to the court that when they filed their motion for reconsideration after the court struck their brief a couple times for being over length, I did file a motion. When they did a motion for reconsideration, I did respond in favor of them being allowed to file their brief. And it's a brief that's 9 times as long as what the court rules otherwise allow. The reason I did that, it's a death penalty case. Death penalty cases typically end up in federal court at some point. There would be federal habeas applying the normal rule that they affirm the state's higher court unless its decisions on matter of law are objectively unreasonable. I did not want to be in federal habeas court in which I was going to be dealing with the argument that I was not allowed, the defendant was not allowed to raise all of his assignments of error because the state court's page limit brief cut him off so that he couldn't even talk about things he wanted to talk about. That was my basis for responding that he should be allowed to file his 450 page brief, make all the arguments he wants to make. I did not want to be in federal court saying, gee, the Supreme Court cut me off. I wasn't even procedurally allowed to argue my case. The result, of course, is we now have this, let's
say confusing,
Well, let
lengthy,
me,
or
let me
lengthy.
try and focus you, if possible. Can you talk to us about the aggravators?
Yeah, and to me, the argument that they've made is essentially comes down to assignments of error 102 through 106. Those are the aggravators, assignments of error. And one of the first comments would just be procedurally default because they didn't make any objection to the jury instructions. So absent any objection to jury instructions, the question is then, did you not preserve that issue for appeal in the first place? The second thing I would say is Judge Randall did do an order that I would refer the court to read because after there was a motion after the aggravator hearing for the court to basically not consider some of the aggravators because the court didn't follow the law on aggravators, and it's really a thing talking about the jury instructions. Specifically, I would refer the court on Judge Randall's order. When you look at the transcript starting at page, if I can get it right, there is an order on the defendant's death penalty motions and objections by Judge Randall. It starts at page 238. And if you go specifically to page 251 of the transcript, it goes into the part about the whether it was error to include mental anguish as part of the jury instruction for aggravator 1D. Judge Randall then goes into an analysis and provides his reasoning for why the objection being made at that time was overruled. And essentially what Judge Randall does is rely upon the Torres case. He cites State v. Torres on the, and the fact that the jury did also find, as far as the alternative and the exceptional death depravity prong, and that the sentencing panel also specifically concluded that the evidence that was presented was sufficient, as found by the jury, to prove the alternative prong of exceptional depravity beyond a reasonable doubt.
So is that a non-unanimous jury finding on depravity, or a presumption that it is a unanimous finding on depravity?
All I would say is I would ask the court to read Judge Randall's analysis that I gave you, whether you buy that or don't buy it, but he does rely upon the Torres case as dealing with the error of
Do you have a response?
the mental anguish, including that in the jury instruction.
Do you have a response to Mr. Pickens' argument that Torres is distinguishable?
Frankly, I don't think it is. I mean, the way I read Torres and is cited by Judge Randall, he explains how in this case, that applying Torres, it was properly applied, and the aggravator 1D of exceptional depravity was proven beyond a reasonable doubt. And so that's the rationale Judge Randall gave.
Is it correct?
I think he's correct, but I mean, the court's going to have to read and decide for itself, but I think he is correct. The other things I would say...
Can you help us with why it was correct?
What's that?
Can you help us with why it was correct?
Why it's correct is because he relies upon the fact of the sentencing panel's finding of the aggravators that were found by the jury, and that those were all found beyond a reasonable doubt, including the exceptional
Is it all
depravity.
consistent with Sandoval?
What's that?
Is it all consistent with the Sandoval opinion?
As far as Sandoval, essentially what Sandoval says, I'm trying to get the term right, but the mental anguish, Sandoval specifically says we disapprove that being in the instructions, even though it's in the pattern jury instructions. We specifically disapprove of mental anguish being in there in the instructions because that's frankly not in the statute and it should not be part of the jury instructions. And then we have Torres where we get the same problem, and then we got the same problem again, but then Judge Randall says that relying upon Torres found that that was okay because the exceptional depravity, the evidence was proven beyond a reasonable doubt, which the sentencing panel so found. The other thing I would also argue, in addition to the Torres distinction Judge Randall makes, the no objection to the jury instructions is ultimately, as was done in Sandoval, I think it can be concluded as being a matter of harmless error. Because the...
How do you have harmless error in a death penalty case?
Well, in Sandoval, you found there was harmless error. And so Sandoval in a death penalty case found that although one of the jury instructions, which was argued was improper on the victim suffering, was an improper instruction, thus tainted that aggravator. The Supreme Court in Sandoval says, even so, that error is harmless, and then looks at...
Because you've got other aggravators, right?
Because you've got other aggravators that were
Not
proven
because
beyond a
of the
reasonable...
depravity prong. I beg your pardon, not because of the depravity prong.
No, it just totally takes that aggravator out, saying that was error for the jury to have been instructed, the instruction was improper.
So
That's the conclusion.
Pickens' argument here today is you've got two aggravators that are bad, and that only leaves you with one aggravator, and that's not enough.
And I don't think that you only have, you do have two aggravators. If you do the harmless error route, you still have two aggravators for the Brumbacks, and frankly, when you look at, and the emphasis of the sentencing panel, the fact that you had these 4 murders committed, and they were committed 5 years apart, just showed that the aggravators that were proven were sufficient.
You've got multiple murders. That's an easy one.
It's multiple murders. You've got multiple murders over a period of 5 years.
How do you respond to Mr. Pickens' argument about there needs to be a crime identified that was being concealed?
The argument I would make on that is, first of all, they didn't object to the jury instruction or tender a more specific instruction defining that term. I think it's pretty self-evident that when you have people being murdered after you have break-ins into a home, that there's another crime that's committed. It's not a traffic violation. We're talking about you're breaking into a home, you're killing people, and they did find...
I beg your pardon, and on the Hunter Sherman murders, what's the evidence of breaking in, quote unquote?
I guess the evidence would necessarily, that's a reasonable implication that when you go into a house and kill people and you have a violent struggle, I think that's just kind of the inference that would be made was, how do you get into the house to do that? He did, and you did have the evidence that he attempted to break in. One of the burglary convictions was for an attempted break-in at one of the other professors' home who wasn't there at the time. And then the fact that he attempted to break in at the one professor's home and then he is not successful and he goes over to the other home, the assumption that he's politely knocking at the door, I think you've got evidence of another crime simply because the evidence of the crime for a jury could easily conclude that you committed the crime of killing these people, breaking into their home, killing these people. That, I guess that also gets me to at least the suggestion that I was making in my brief when I essentially kind of said, there's so many assignments of error here. What is the court going to look at, be actually concerned about, or wants a little more than what the parties gave them?
Could you please today address sort of cumulative assignment of error in regard to ineffective assistance of counsel?
Well, historically, what you do on...
Isn't that kind of the elephant in the room in this case?
Not necessarily. I think the cumulative, historically, when you get a cumulative error, you have to find that errors have been proven.
Well, excuse me, I used the word cumulative, and perhaps I didn't mean it in the sense you're responding to it. Okay. There are a number of more specific allegations about incompetency, or excuse me, ineffective assistance of counsel here. And if you could address them, that would be very helpful to the court.
My problem I'm having is we've got 60-some assignments of error on ineffective assistance of counsel.
Are there any we can reach on this record? Which of the 60 or so assignments of error pertaining to ineffective assistance of counsel can we reach on this record? And then let's talk about those.
That's a pretty difficult question to answer during an oral argument when I've got 60 of them, and then just go through. Frankly, I think that would be something that I would suggest supplemental briefing is going to be more helpful than saying assignment of error 12, 13, 18.
We don't normally do supplemental briefing after oral arguments unless it's an issue the court has brought up itself.
Well, I've had cases where after the oral argument the court does ask for supplemental briefing because the nature of the case or issues or the court thinks supplemental briefing would help. I would think this is such a case. It's a death penalty case. It's a voluminous record. It's a confusing, very extensive brief, and issues such as, are there assignments of error on ineffective assistance of counsel that under our jurisprudence we can address at this time and thus take them off the table? That's also necessarily going to involve reviewing a 7,500-page bill of exceptions, which opposing counsels even acknowledge he hasn't read. All of it I have. And I was lucky enough that the court reporter honored my request when I knew this case was coming way back when. Can I get an advance copy of the bill of exceptions in a PDF form, which then I got and I've had time to read. The problem that gets very apparent from that is if you start going through that, addressing a specific assignment of error that appears to be of some concern, you really have to focus more than I think the focus has been.
One of the arguments, it seemed to me, to be in the defendant's brief was that after Ms. Mata was taken off Team Mata, and I believe it was repeated here in the courtroom today, she was the person who knew what was going on, and the other members of the team did not know what was going on, and that the team that remained spent most of their time trying to protect Ms. Mata's reputation and their reputation and not in defending Mr. Garcia, and that at some point in time Mr. Garcia got so frustrated with his counsel that he refused to talk to them thereafter.
I don't think the record's sufficiently clear to say that's actually what was going on with the defense team. or that was her role, or that was the effect of removing her, or that you couldn't have asked for a continuance if you were going to find out that removing her meant that we're now short-staffed on dealing with. I think all of those types of things are not sufficient in this record to reach that conclusion one way or another. I would say the competency order that Judge Randall eventually entered, he entered an order on competency on March 28th, 2017, in which he agrees with Dr. Hartman and also Judge Randall's observations of the defendant was essentially malingering. He seemed to be able to respond when he wanted to, and so he had a concern that we have a defendant who appears to be malingering, and then the defendant, in various points through the record, where the judge is concluding that is the defendant who's electing not to communicate with his counsel, which, if he doesn't want to communicate with him, as far as Judge Randall's concerned, that's his choice. But I don't think that turns into ineffective assistance of counsel. That turns into a defendant who decided he didn't want to cooperate with his attorneys, but he didn't want to represent himself either.
Is there enough?
I don't think that's ineffective assistance of counsel.
Is there enough in our record for us to find an actual conflict, that Team Mata had an actual conflict and therefore kind of jump to the presumed prejudice discussion?
I don't think so.
Why not?
There's not enough in the record to explain what's going on with counsel. We don't have any evidence on strategic decisions made by counsel, why counsel is doing some things, why they aren't doing other things. The record just is not sufficient to just say we can reach that conclusion from reading this. You might have an impression, but that's not sufficient to reach a conclusion of a conflict of interest that prejudiced the defendant. The fact that someone is removed from the case and you still have attorneys, a team of lawyers representing the defendant, you've got the commission jumping in at some point in time. They're also appointed. We have Judge Randall lecturing the attorneys that you all have to cooperate and work together on this, which they seem to acknowledge.
Is your argument ultimately that this needs to be, the can needs to be kicked down the road to post-conviction hearings on all this?
I think probably all of us is going to end up there, except I think Judge Stacy's very good question is, of all of these assignments of error, are there some that we could decide now, the record's sufficient to decide them now, and if so, which ones?
Can you help us with that?
I think I can help you very much. I would like to help you on a supplemental brief if the court wants that specific question answered. Otherwise, a lot of this is going to be kicking the can down the road. They've made the argument that the Supreme Court's procedural default rule should be overruled. And I think the Abdullah case does a very good job of explaining why Nebraska Supreme Court has not adopted the federal Massaro decision. And for judicial efficiency, I think that makes a lot of sense. And I'll frankly acknowledge, I've told district judges that if you get this voluminous post-conviction motion, if you just simply deny it, defendant appeals, it goes up to the Supreme Court, and the Supreme Court will then tell you what, if any, claims on which you have to have an evidentiary hearing. The appellate process on a direct appeal could be so apparent on some assignments of error that you can look through a 7,500-page bill of exceptions and say, from looking at this here, we can see that assignment of error 22 on ineffective assistance of counsel has no merit. But the problem is just we've got a brief that's 9 times as large as we've ever had. We've got an extensive record, and I think it's a rare case, but it's a rare case in which I think, and it's a death penalty case, And I think supplemental briefing would be helpful, but it may be more helpful if we know issues that the court wants us to more specifically address with helpful annotations to the record as to where we can find these things, and also...
You want us to give references to you?
No, we would do that. We would do that. I think that's helpful to the court.
It sounds to me like you're seeking a supplemental briefing order that says, please identify the assignments of ineffective assistance of counsel that can be reached on the existing record and the proper disposition
Would
thereof.
be helpful.
That's what you're seeking.
Yeah.
All right.
I think it would be helpful to us. I think it would be helpful to the court.
I want to ask you about the jurisdictional argument regarding the non-capital convictions. Your opponent argues that Rust is distinguishable. I'll take it a step further. Is Rust simply wrong as a matter of statutory interpretation, particularly looking at Section 29-2525?
It may be. The reason I put that in the brief was the Rust case is there, the language is there. If the case is wrong, then the issue is, should the court issue an opinion just saying, we overrule that? I jeopardized everything. I couldn't find any subsequent case that addressed that issue. It may very well be wrong under the idea that the statute, what the statute says, you get an automatic direct appeal.
In a case.
In a capital case.
Yeah.
Well, I'd have to read the statute again. I'm not sure if it uses the word case or whatever used.
Well, the opening phrase, I'll give you the help. In cases when the punishment is capital, no notice of appeal shall be required.
Yeah.
And then blah, blah, blah.
Yeah. And my thought was, if that's wrong, it should be brought to the court's attention, and if the court then wants to overrule that, it should, and then nobody's going to be relying on that anymore. I did put that same jurisdictional statement in the Trail case, which was recently affirmed, and there wasn't any comment in the opinion about it at all. But I did find it troubling. I always find it troubling when you have a case out there, there's a specific quote, and the court has not yet overruled it, maybe should. Because what I tend to see on these death penalty cases is the clerk just sends up the appeal. It's a mandatory direct appeal. There aren't any notices of appeal on collateral convictions, but we still have the language here in which, in the Rust case, to me, when I read that case, they didn't say no assignments of error. They said no appeal. And that's different than saying no assignments of error made. It says no appeal was taken, and so thus they don't address any of the other counts. Right or wrong, whatever. I have no problem if the court overrules it. If the court agrees with it, fine.
Or just simply saying that wasn't what we meant.
That's fine. Yeah. Distinguish it. I know the court doesn't like to overrule cases, but if it wants to distinguish them so nobody's
relying on that.
Yeah, in the future. And I think in a death penalty case, jurisdiction's important. And to me, it's always should be the first issue the court looks at. I've always done that I look at the jurisdictional statement, take that serious. And because I know the court sua sponte can say no jurisdiction, and it's done that a lot. So.
Thank you.
So, obviously, I've lived with this case a lot longer than the court has. It's voluminous. It's overwhelming. The briefing is such that I don't know how helpful it has been. I think it could be more helpful if the court would ask for supplemental briefing upon seeing the issues, because I mean, if we're talking about assignments of error 102 to 106, that's buried pretty deep in a brief. And I can only remember my arguments. One time I remember there were like 30-some assignments
I
of error. and I
want to ask you a little bit about the equity of that, since if we ask you to, for example, specifically point out the issues of ineffective assistance of counsel that can be disposed of on direct appeal or not, are we to ask the same thing of the defendant in this case? Haven't they already done that?
I think it's how you phrase it, but I think it is fair for the court to ask supplemental briefing on what assignments of error, because they're saying some assignments of error cannot be disposed of on direct appeal. Some can. I think it's helpful to know which assignments of error actually can be disposed of on direct appeal, which necessarily means the ones that can't be disposed of on direct appeal are still there.
I probably should have asked the question of your opponent, but I'm going to ask it of you in case he gets a chance to say. Is another elephant in the room the appellant's brief in this case and the difficulties that it poses, as both parties have talked about? Is this a case where replacement briefs would actually be useful?
I do think that would be helpful. The problem is the court going to impose a page limit on replacement briefs?
Of course, they're now word limits. So.
Or word limit, yeah, that's true. Is the court going to say not to exceed, whatever? Fine, I think that's helpful, but yeah, if you want to talk elephant in the room, that's almost probably one of the biggest elephants with the entire case.
Let me just follow up on that thought, if I may, and perhaps we all agree not all assignments of error are created equal. But in the direct appeal context, is there not an obligation to raise, I want to say, all of the issues for which there may be merit by an appellant in the capital case?
Well, there's an obligation to raise all issues. Whether or not they have merit or not, I guess is they should, but they don't. And that gets back to what was my concern. This case ends up in federal court on federal habeas. I do not want to have the argument that the Supreme Court of Nebraska put a page or a word limit on me that effectively meant I wasn't allowed to make these arguments that I think are meritorious. I think that's a legitimate concern. Federal courts are required to uphold the decisions of a state's highest court as long as they're not objectively unreasonable, which would necessarily imply that defendants, especially in a death penalty case, were given the opportunity.
Argument that there should be supplemental briefs, but we shouldn't put any limit on them?
If we got if the court, I mean, the court's got the briefs, it's got the 160-some assignments of error. I know this court, quality of its work, I would expect the court itself should be able to identify out of those 100-and-some assignments of error which ones it believes would be helpful to have more briefing, more focused briefing, general issues it might want to be better addressed. And it's an unusual case. The fact that it's a death penalty makes it another unusual case. I know when there's going to be post-conviction, most likely, the defendant's going to be entitled to have counsel appointed in post-conviction because this court has reversed a case, I think it was Galindo, where the defendant was denied counsel in a death penalty case at post-conviction. It was reversed with directions to appoint counsel. So he's going to have counsel at post-conviction. So I think a lot of this stuff might be able to be eliminated by having more focused briefing on which assignments of error can be disposed of or not disposed of on the record that we have that has annotations for the court's benefit as to why that is so. We don't have that.
Why didn't it happen the first time?
I guess I go back to the length of the record, the confusing nature of the brief, the difficulty actually reading that brief, figuring out what are the assignments of error that are actually significant enough that need to be thoroughly addressed. And as I said before, when you're up here making your biggest pitches on assignments of error 102 to 106, it is somewhat difficult to say, gee, until now I didn't. Yeah. For me, I'm used to, if you're going to do an assignment of error, your best one should be 1, second best 2. It shouldn't be 102, it shouldn't be 103, 104, 106, which doesn't really give one much help to figure out what are we really looking at here seriously that may have some merit. So, like I said, I worked with the case a long time. I eventually kind of reached the point that I did somewhat throw my hands up in the air and conclude that this is a unique case. It's a very extensive case, and I think it's a case the court wants to get right. And to get it right, it probably is helpful if we do supplemental briefing on assignments of error, because we already know from the opposing counsel's oral argument 102 through 106 appeared to be significant. It's on the aggravators. So,
Thank you very much.
thank you.
Do we have time for rebuttal?
No, Your Honor.
Mr. Pickens, I do want to hear from you, however, on the issue of supplemental briefing.
And replacement briefing.
And replacement briefing.
Right. I guess I want to start off by quoting Justice Castle from a seminar I attended. I think a lot of the problems in the appellant brief is due to the tyranny of page limits. I really, when you look at the assignments of error and we're incorporating this prior one and all that language that makes it so difficult, even with the extensive pages that you allowed, there were still problems. I don't think the answer is an 800-page brief.
I guess the candid question that I would submit to you, because you're now in the place of your former colleague, and we all have respect for your former colleague, and I don't ask the question to disparage her in any way, but if you had your druthers, would you rather restart with a different appellant's brief?
Well, I'm down one lawyer, and I can't hire another lawyer until the legislature adequately funds our office. We are declining appointments in every case except murder cases. So if you want me to write a brief to start over again, it's going to take me a long time because I have other things to do, and of course my lawyers are all extremely busy, and I intend to retire next summer. And Mr. Smith made a comment to me before we came in here that briefs like these could cause a lawyer to retire. And so I guess I'm not going to argue against replacement briefs, but it will be difficult for our office to do one. It will take us a significant amount of time. It's not something we could crank out in 2 or 3 months. Is that all you wanted me to address, Chief Justice?
I think.
Okay, thank you.
Well, just with respect to supplemental briefing, even if we don't do replacement briefing and we do ask for supplemental briefing, how should such a supplemental briefing order be articulated that you think would be helpful to this court?
I don't know. When the Chief Justice asked a question about supplemental briefs, I don't have experience with that as Mr. Smith might, but I have seen other cases where that's been done, and it seems to me it is typically done when the United States Supreme Court comes down with a decision that affects the case after the case has been argued. That's when I've seen it. Justice Stacey has a good idea, I suppose, about, with the IAC issues, which can be addressed now. But I think Ms. Newell did that in her brief. I think that's already been done. I don't know if Mr. Smith agrees with that. I don't really have a recommendation. We obviously will do whatever you want us to do.
Thank you.
Thank you.
Thank you very much, counsel. That concludes arguments in State versus Garcia. And with that, you are excused, and the court is adjourned for the day. Thank you.